Welcome to our Savvy series. I'm Catherine Magana here with Rachel Ivanovich. And today we're going to discuss 6 of the biggest mistakes when women make when inheriting a large sum of money. And so when you inherit money, there's a lot of tax-related things to consider and also other mistakes to consider in making sure that you are making the right decisions. And so one of those is failing to account for estate and inheritance taxes. And it's interesting, as I was kind of looking, we're now ending that 2024, and the threshold for individuals this year was $13.61 million. And for next year in 2025, it's actually gone up a little bit. It's $13,990,000. So those are some things to make sure that, depending on the size of the estate or if you inherit money, that extra money you're inheriting, are you still within some of those parameters? And that obviously changes.
And we really have seen a lot of people inheriting money recently. We've
yeah.
had a lot of clients come in. So if you're in this situation, please call us. We'd love to chat with you. Our number here is 760-692-5700. But one of the things we really have seen, because you're saying, Catherine and Rachel, we're not going to inherit $13 million. Yeah. But one of the things that might shock you is there is something called an inheritance tax that you may not have heard of. A lot of people have heard of estate taxes, but not of inheritance tax. And I have a lot of clients call my office and say, hey, I just inherited some money. I want to make sure I'm planning for my taxes, and you might be in the same boat. What you need to know is there are only actually 6 states that impose an inheritance tax.
Oh, interesting. Okay.
Soon to be only 5, because Iowa passed a law saying that they're phasing out their inheritance tax. But we do actually have a client in Maryland, and Maryland has an inheritance tax and it depends if you inherit the money from, and you're a child or a parent, if you're a spouse or grandparent, so a lineal descendant, or if you're a sibling, so the tax rate's different. So for instance, if you're the child that you're inheriting and you live in Maryland, they impose a 1% tax. Wow. But if you're a sibling, it's a 10% tax.
Oh, really? Interesting.
I thought that was fascinating too. Wow. And we're here in California, but let's just say you inherit a property from, let's say, a parent that's living in Maryland. You won't pay inheritance tax in California, but you will have to file and pay in Maryland. Wow. So keep that in mind. The other states that impose this tax are Pennsylvania, Kentucky, Nebraska, and New Jersey. Wow. So.
I'm surprised California doesn't.
I know,
like,
me
wait
too.
A minute, because
they impose tax on everything else.
I know. So another kind of mistake is not understanding capital gains on inherited assets. And so when you inherit assets, it could be stocks, bonds, real estate. And usually, depending on how the estate is set up, but there are a lot of times where when the beneficiaries inherit assets, that there could be a step up in basis. And so that doesn't happen all the time, but most of the time and very frequently it does.
And we get lots of calls on this as well. People, like I said, call my office, ask, okay, I inherited, my parent passed away, inherited their house. So if you inherit a primary residence or really any other real estate that's not held in an irrevocable trust, you will get that step up in basis, meaning the cost basis, it resets to whatever that asset's value was. The house, your parents bought it for, $50,000 back in the 60s, and now it's worth $2 million.
Correct. So they use date of death or the 6 months after.
Correct. So you can turn around and sell it and not pay any capital gains on it. So you definitely need to, look at that and get a valuation done. Call a realtor, make sure you get some sort of fair market value valuation.
The other thing that we've seen a lot this last year is for spouses. So even if you're married, potentially there's some step up, and depending on which state, obviously, you're in. But those are some conversations we've been looking at and having as well.
Yeah. So that one of the third things that also ties in is when you inherit IRA accounts. And that there's been a lot of talk about those because the Secure Act came out, the Secure 2.0 Act came out. So it's really confusing. And people have called our office a lot asking, do I have to take all of it out? Do I take it out over 10 years? So you definitely need to know what the rules are if you inherit an IRA, and it really depends on what the relationship was.
And so prior to the Secure Act of 2.0, a lot of beneficiaries were able to spread that over life expectancies, whereas now there's the 10-year rule for those that aren't spouses. And once again, there's different rules depending if they're minors or non-minors. And with that, there was some question about if the decedent was taking RMDs, required minimum distributions, or not. was that part of the 10-year? And
Exactly.
what the guidance came out recently said is, well, now if they were taking RMDs, you have to take RMDs, and they're going to put that back in effect in 2025. So there are little moving parts, and with that, once again, it's kind of case by case looking at
what's your relationship to the decedent,
and then also how much is there, and then because that whatever you take out does get added onto your taxable income.
So you want to do the tax planning.
Yes, so definitely some tax
And if you
planning.
miss that required minimum distribution from the IRA, there are penalties.
Yes.
So you want to be want to be talking to your tax advisor, call us up. We're happy to talk to you, because there used to be a 50% penalty. It's now a 25% penalty if you fail to take that required minimum out of the account. So definitely want to make sure that you're taking the money when you're supposed to, and that you're choosing the right distribution option.
And that's kind of the fourth item, is looking at what's the best distribution option. Do you take a lump sum? Do you spread it out? If you're a spouse, at what age are you? Can you spread that out over your life? If you're a spouse and if you're under the requirement distribution age, you can wait and take it out later. But there's a lot of different nuances and rules behind that. And once again, it's kind of case by case.
Yeah, because I think you really need to be looking at what is my income this year, and what is my income going to be in the next couple of years. Because if you do have a year where, let's just say, your income is down, you may want to consider that lump sum distribution.
Well, and then the other thing we've been looking at for some clients have inherited some assets, IRAs, and are taking a little bit of money out, is there are also some gap years between taking Social Security and retiring, and so we have to look at all of that and say, okay, are there partial Roth conversions to consider along with this too? So,
or will I be taking Medicare soon, and will my income be boosting into the bracket that I'm going to actually have to pay the surcharge or the IRMA? So you definitely have a lot of planning opportunities and reasons to call us.
Exactly. Okay, and then number 5 is neglecting charitable contributions for tax deductions. So obviously there's different ways you could give, and making sure that you look at that.
And we've had a lot of clients who have recently inherited money or had a windfall, and they really want to give to charity. And I think that it's important to talk with a professional to ensure that you're not missing out on double tax benefits that are out there. So for instance, if you inherit, let's just say, stock, and you hold on to it for a while, let's just say, and it appreciates in value, and you can actually, instead of selling the stock and donating the proceeds, you can donate the stock and the appreciation, which normally would be taxable, you don't have to pay tax on, but the charity does get the full benefit of that gift.
Nice, yeah. So there's charitable giving, and then also the other thing we're looking at with giving is, gifting within family members, and how does that impact your plan and giving just, inheritance as well.
And some people do like to consider donor advised funds. It's not for everyone. And then there's also qualified charitable distributions. That it's a way to reduce or take money out of your IRAs and gift a charity, but you do have to be over 70 and a half to take advantage of this strategy. But it's definitely a great way to reduce your tax liabilities while really fulfilling those philanthropic goals that you have.
And then lastly, number 6 is not setting up a trust for asset protection and tax efficiency. And so that's a big one, yes. And so it's interesting because as we do planning and retirement plans, we're looking at the assets, and then we have those conversations. And we're not estate planning attorneys, but we know enough to say, okay, you should speak with an attorney if you don't have something in place. Or if you do have something in place, are you utilizing your trust properly, or is everything titled properly? But it was interesting. We actually had a client recently. It was a younger couple. She inherited some money from her grandparents or her grandma. And we had the conversation prior about a trust, but they kind of put it aside and said, eventually we'll do this. Well, once they inherited the money, they realized, and also seeing what the family went through with the
probate.
And all, so they realized we need a trust. So I said, yes. Yeah. So definitely something to help the estate and avoid extra taxes and cost.
And every state has different rules when it comes to trusts. So definitely do your due diligence.
And there's a lot of good estate planning attorneys. And then each state, like you said, has a different
threshold, different rules, et cetera. Yeah. But honestly, if you neglect this and you make that mistake, it really can lead to higher tax burdens. And so there's ways to prepare and keep your taxes at a minimum.
So we covered a lot. So once again, there's some mistakes that are out there, but with the proper guidance and planning, we obviously want to make sure you're making the right decisions. If you'd like a complimentary strategy session with us, you can reach us at 760-692-5700. And we appreciate you joining us today. And remember to savvy up. Please stay tuned for important regulatory disclosures.
Savvy Women Wealth Management is an SEC registered investment advisor. The opinions expressed in this program are for general informational purposes only and are not intended to provide specific advice or recommendations for any individual or on any specific security. It is only intended to provide education about the financial industry and how we may be able to assist. To determine which investments may be appropriate for you, consult your financial advisor prior to investing. Any past performance discussed during this program is no guarantee of future results. As always, please remember investing involves risk and possible loss of principal capital. Tax considerations presented may not be appropriate for every individual circumstance. A tax professional should be consulted before making any decisions about your tax liability.